Part 4 of Henry Wirz, Commander of Andersonville Confederate Prison, Trial and Execution, by United States Army Staff Judge Advocate. Part 4, Closing Statement of Judge Advocate, Prosecutor. Part 9. Without pretending to make an argument in this connection, desiring only to aid the court in determining the fact, I will try to arrange the evidence under this branch of charge second in chronological order. The first proof of injury by the dogs where death resulted was some time in the month of May, 1864. I have already cited at some length the testimony of the witnesses bearing upon this point, and will not recapitulate, but will merely refer the court to the witnesses. They are William Henry Jennings, page 1246, manuscript, page 545, Bernard Corrigan, page 1351, manuscript, page 598, and James E. Marshall, page 1714, manuscript, page 766. Another case which is clearly defined in the evidence occurred about the 11th of July, and is stated with some particularity of time, place, and circumstances by a witness whom the court must remember as one of intelligence and candor. To his testimony I call especial attention. It has already been briefly cited, but I will give his language in greater length. John L. Yonker, after having related the circumstances as I have before given them, goes on to narrate, page 2186, manuscript, page 947, the death scene of his murdered comrade, and what occurred at the time, and from all the circumstances, together with the dying declarations of the unfortunate victim, we have presented a clear case of murder. Question: Did he, the dying man, in that same conversation say anything as to how he had been injured? Answer: Yes, sir. Question: State what he said. Answer: We questioned him, and he replied in a feeble voice that he had got about 35 or 40 miles and was strongly pursued by the hounds; that as he was very weak, coming out of the hospital, he tried to climb up a bush, but was pulled down by one of the hounds, and so disabled that he could proceed no further. We had to stir him up once in a while, give him a regular shaking, so that he might answer a few more questions, because he was expiring. I saw him after he was dead. Question: When was that? Answer: Just a few days before the 6 raiders were hung, which was on the 11th of July. The testimony of Joseph Adler and George Conway, heretofore cited, corroborates, if that be necessary, the testimony of William Yonker. Another case which stands out clearly in the evidence is that related by Thomas W. Way, page 1256, manuscript, page 552. This witness, in company with 2 comrades, had made his escape. They were overtaken by the dogs. This is his testimony on that point. Question: Do you remember anything about a soldier being torn to pieces by hounds? Answer: Yes, sir. He was a young fellow, whose name I don't know. I knew him by the name of Fred. He was about 17 years old. When we heard the dogs coming, I and another prisoner who was with me, being old hands, climbed a tree. He tried to do so, but he had not got up when the hounds caught him by the foot and pulled him down, and in less than 3 minutes he was torn all to atoms. Question: Was Turner there? Answer: Turner was close behind. He got up just as the man was torn to pieces, and secured the hounds, and we came down. Question: Did Fred die? Answer: Yes, sir, I should think so. He was all torn to pieces. Question: Was any other of your number torn at the same time? Answer: No, sir. Question: When was that occurrence? Answer: In the latter part of August, 1864, just before we were moved from Andersonville, which was on the 24th of August. Question: What did Turner say at the time? Answer: He said, "It is good for the son of a bitch. I wish they had torn you all 3 to pieces." It would seem impossible to doubt a statement so clearly made and under circumstances calculated to impress the incident indelibly upon the mind of the witness. Corroborative of Mr. Way, however, is the testimony of Samuel Frank Maddox, who says, page 1168, manuscript, page 513, that Turner told him one day at the graveyard that he had let the dogs tear a man to pieces in the woods, which, from coincidence of time and circumstances, seems to be the same incident as that given by Way. The next case of murder by dogs, and as clearly defined as any previously given, is the one related by Dr. A. W. Barrows, who was on duty in the hospital. He says, page 244, manuscript, page 87, I remember a man making his escape from the hospital in July and being overtaken by the hounds. A large portion of his ear was torn off and his face mangled, and he was afterwards brought into the hospital. That man got well. This was in July or August, 1864. I do not remember the exact date. I remember also that at the end of August, or in September, 1864, a man who had been bitten badly by the dogs, in trying to make his escape, was brought into my ward and died. The wound took on gangrene, and he died. He was a Union prisoner. Q. Was he trying to escape from the stockade or from the hospital? A. I am not certain. Q. When did he die? A. I cannot state the exact date. It was either the last of August or the forepart of September. Q. How many days after he was torn by the dogs did he die? A. Well, if my memory serves me right, I should say 4 or 5 days after. I know the wound took on gangrene and he died. Q. Did he die from the effects of the wound? A. Indirectly, I think. He did not directly. It was from the effects of the gangrene. Q. Was the gangrene manifested in the wound or elsewhere? A. In the wound, in no other part. He was bitten through the throat on the side of the neck, and gangrene set in, and he died. Q. Was the gangrene the result of the bite, in your opinion? A. Yes, sir, it was. This is confirmed by the testimony of James P. Stone, already cited. Of the facts as presented by Dr. Barrows's testimony there can be no doubt. He was an officer on duty in the rebel hospital, and is a gentleman whose credibility has in no way been doubted. It might perhaps be urged on the part of the defence that as the witness states that the death of the prisoner occurred from gangrene directly and from the wound indirectly, the benefit of the doubt thus raised must be given to the accused. Let me remind the court of the law governing in such cases. It is laid down in 2 Starkey's Evidence 711 that it is sufficient in law to prove that the death of the party was accelerated by the malicious act of the prisoner, although the former labored under a mortal disease at the time of the act. And it is sufficient to constitute murder that the party die of the wound given by the prisoner, although the wound was not originally mortal, but because so in consequence of negligence or unskilful treatment. The evidence shows in this case that the patient died of gangrene, that the gangrenous affection was confined to the wound, that he was not so affected before the wound, but was affected immediately afterwards, that he did not die of any other disease or malady. The fact, therefore, being clear that the death was occasioned or certainly accelerated by the wound, there is no other course left you but to find that the case stands in the same position as if the man had been killed on the spot by the dogs. We have thus presented a classified analysis of the evidence bearing upon the charge of murder by the use of hounds. The only defense set up under this charge is given in the statement made by the accused to the court, and is an attempt to confound the prisoner Frenchy with all the instances given by different witnesses. And as it was shown in the evidence of the defense that Frenchy did not die, you are asked to conclude that this prisoner must be acquitted of this branch of the charges. Now, it has not been assumed at any time by the prosecution, nor was an attempt made to prove it, that the man Frenchy, so called, was killed. The incident referred to by the defense was one occurring within plain sight of the post. The witnesses Heath, Castellan, and Mohan, rebel officers, testified with regard to it early in the prosecution, and made the facts so clear that it is somewhat surprising that counsel would attempt to raise a reasonable doubt in behalf of their client by an attempt to confound this case with the numerous others so clearly and distinctly defined in the testimony. The court will bear with me a moment while I give in this connection a part of the prisoner's own statement of the Frenchy occurrence, and I give it for the reason that it discloses a fact which has been persistently denied, that the hounds used were ferocious and dangerous to human life, and for the additional reason that it shows from the prisoner's own admission his control over the dogs and his responsibility for whatever injury resulted from their use. The language of his statement is this: Frenchy again effected his escape by jumping into a thicket near the creek. The matter was reported to me. I had the dogs sent for. They soon came on his track. He took to a tree. One of the pursuing party, not I, fired a pistol close to him to induce him to come down. He was not hurt, but he dropped or fell from the tree into a mud hole when the dogs rushed upon him. I jumped on the dogs and drove them off. Here, as elsewhere, it would have been safer and wiser for the accused to have rested his case upon the evidence without attempting explanation. In the next place I will proceed to recite the evidence as to cases of death from confinement in the stocks and in the chain gang. William Krause, page 1459, manuscript 642, states that a few days before the raiders were hung, which was the 11th of July, a man died in the tent next to the one occupied by witness, that the death occurred the next day after being relieved from the stocks, in which he had been confined about 2 weeks without intermission. George W. Gray, page 2699, manuscript page 1157, testified that he was in stocks the last of August or the 1st of September, and that the third man from him, a sick man, died while in them, that the negroes took him out of the stocks after he was dead and hauled him away. Nazareth Allen, page 744, manuscript page 305, states that in August 1864 he saw a man who died in the chain gang or stocks. He thinks it was the stocks. Alex Kennel, page 1291, manuscript page 556, testifies that in February 1865 a man was taken out of the stockade in the evening and put in the stocks and kept there all night, and that he died in 8 hours after being released, that the man said he was chilled till he was insensible. James P. Stone, page 2212, manuscript page 956, testifies that he thinks it was sometime in June, a man in the chain gang sick with chronic diarrhea, that he was kept in the gang until it was impossible for him to move, that he was taken out and left at the guard house near the stocks. The band was left on his neck and the ball on his leg, and he died with these on him. James Culver, page 2080, manuscript page 914, testifies that he saw 12 men in the chain gang almost every day for a month or 6 weeks. One of them was very poorly and looked as though he could hardly carry himself. Those in the gang complained about his being sick. He caused them a great deal of trouble by reason of his having diarrhea. Witness afterwards saw the man out of the gang, but he still had the ball upon his legs and the band about his neck. He afterwards died in the guard house. Witness saw the irons taken from him after he was dead. He died in 3 or 4 days after being taken out of the chain gang. The witness thinks he died sometime in July. In connection with this, some testimony given by Heath, Dillard, and Honeycutt, rebel soldiers who were on duty at Andersonville, may be pertinently introduced. John F. Heath, page 780, manuscript page 317, testifies that in the month of August, 1864, a man was sick in the chain gang, and the gang objected to his being in it because of his condition; that there were 12 men in the chain gang. William Dillard, page 803, manuscript page 328, testifies that in August he guarded the chain gang one day and night when 12 men were in it. One of them was very low and had to go out every 5 or 10 minutes. that the others of the chain gang wanted him taken out, that when the man was taken out he could just stand up. Calvin Honeycutt, page 824, manuscript, page 336, states that he guarded the chain gang for 1 or 2 days and nights, that one of the men was sick and the rest wanted him taken out. John Pask, page 1695, manuscript, page 757, states that sometime in July he saw a man put in the chain gang and saw his dead body after he was taken out. Robert Tate, page 2650, manuscript, page 1133, testifies that on one occasion, he does not know the date, one man was put in the chain gang when very sick, that he remained in it for about 2 days, that the surgeon told the prisoner that he had better take the man out, that the prisoner gave orders to have him released, and the next morning he saw him hauled away to the graveyard. The evidence here briefly recited presents 2 distinct murders by the use of the stocks and one by the chain gang. The cases presented by William Krause and George W. Gray, cases of death by the stocks, come directly within the general principles of law before cited. The witness Krause, after narrating the circumstances as heretofore briefly given, testifies as follows on cross-examination. Q. Was there anything the matter with him besides being in the stocks? A. No, sir. He was a hearty man before he went there. Q. You did not see him in the stocks outside? A. Yes, sir, when I went out to get some medicine. Q. How many times did you get out in that way? A. I used to go out nearly every other day to get medicine. Q. Was not the doctor's place close to the gate? A. Yes, sir, about 20 feet from it at the upper end, the southwest end. Q. Could you see the stocks from there? A. I could. Q. How far was it from where you got the medicine to Captain Wirz's headquarters? A. About 300 feet. Q. With nothing to obstruct the view? A. No, sir. Q. And you saw the men in the stocks for 2 weeks when you went out in that way? A. Yes, sir. Q. How was that man injured who died? A. Weakness. He was starved. Q. Was he not starved instead of being hurt by the stocks? A. That was one thing that killed him. Q. Was it not the principal thing? A. Yes. This occurred, as the witness states, about the time the raiders were hung. The evidence, it is true, does not present a case of death directly attributable to the stocks, but it is clear that death resulted from a conjunction of circumstances, of which the stocks was one important element, all being the result of the orders of the accused. It is immaterial whether the man died from the injuries inflicted by the stocks alone. The circumstances fully bring the case within the principle already cited, that it is sufficient in law to prove that the death of the party was accelerated by the malicious act of the prisoner. The second case of this class is presented by the testimony of George W. Gray. The witness had made his escape, was caught by the dogs, and returned to the prison. He testifies, page 2698, manuscript, page 1157, I was brought back to Andersonville prison and taken to Wirz's quarters. I was ordered by him to be put in the stocks, where I remained for 4 days, with my feet in a block and a lever placed over my legs, with my arms thrown back and a chain running across the arms. I remained 4 days there in the sun. That was my punishment for trying to get away from the prison. Q. Do you know anything about a person dying in the stocks? A. I do. At the same time a young man was placed in the stocks, the third man from me. He died there. He was a little sick when he went in, and he died there. Q. Do you know his name? A. I do not. If I heard it, I have forgotten it. Q. When did this occur? A. That was about the last of August or the 1st of September, 1864. Q. Are you certain he died? A. I am. The negroes took him out of the stocks after he was dead, threw him into the wagon, and hauled him away. This witness is strongly corroborated by the rebel soldier Nazareth Allen, who, page 744, manuscript, page 305, testifies, Q. Do you know anything about a prisoner having died in the stocks? A. Yes, sir, one died in the chain gang or stocks. I won't be certain which, but I think in the stocks. Q. When was it? A. I think sometime in August, 1864. Q. Do you know what was the state of his health when he was put in? A. I do not know what his sickness was. Q. What was his appearance? A. He appeared to be sick when I saw him. I saw him only once or twice, and afterwards I saw him dead. Q. How long was this man confined in the stocks? A. I cannot say. There were several in the stocks. Q. Do you know for what this man was placed in the stocks? A. I do not. I think it was for trying to escape. Q. Where were these stocks or this chain gang with reference to Captain Wirz's headquarters? A. They were between Captain Wirz's headquarters and the stockade. Q. On the road you would take in going to the stockade? A. Yes, sir. In reference to this occurrence, Gray is so strongly corroborated by Allen that I do not deem it necessary to comment on the evidence more particularly. There is still another case of death by the use of stocks to which I ask your attention, as giving, besides the fact itself, proof that these punishments were continued until almost the time of breaking up of the prison. This is the case mentioned by Alex Kennel, who says, page 1291, manuscript, page 566, I have seen them, the prisoners, put in the stocks. One special act which I know of occurred last February. In that case a man was taken out of the stockade in the evening, about 4 o'clock, and kept in the stocks all night. He was turned into the stockade the next morning at 9 o'clock, and he died in less than 8 hours. He died in the stockade. Q. What was the condition of the man when taken from the stockade? A. He was apparently as healthy as any prisoner in the stockade. Q. What was done with him during the night? A. He was kept all night in the stocks, which were outside the stockade. Q. Did he die from the effects of the stocks? A. That was his supposition. It was a very cold night. Q. Did you talk with that man during his dying moments? A. Yes, sir. I talked with him an hour before he died. Q. With what belief was he impressed? A. He was impressed with the belief that he was chilled to death that night in the stocks. Q. Did he expect to die? A. He did not expect to live from his conversation. He did not eat anything after he came into the stockade. Q. What did he tell you? A. He told me that he was kept in the stocks from the time he was taken out until about 8 o'clock in the morning. He was chilled so thoroughly that night that he was insensible. Q. Did you see him after he died? A. I helped to carry him to the gate. Q. Did you know his name? A. No, sir, I did not know his name. I never inquired it. He belonged to a Pennsylvania regiment. Q. You are certain about the time? A. I am certain that it occurred about the 15th of February, 1865. I come now to notice the deaths resulting from confinement in the chain gang. There is some evidence of more than one death having occurred by these means, but aside from one instance the testimony is so vague and unsatisfactory that I do not ask the court to consider it. There is one case, however, so clearly defined, so fully proved, as to admit of no doubt. This is the case, the court will readily remember, as occurring in the chain gang of 12. The facts in this case are given so clearly and by so many witnesses, a synopsis of whose testimony I have already presented, that the circumstances, I have no doubt, are fresh in the memory of the court, and I will therefore consume no further time by quoting particularly the evidence. The eye-witnesses of this occurrence, which seems to have been one of the most sad and cruel of the whole list, present an array of testimony which cannot be overthrown, and which there has been no attempt on the part of the defence to explain away. The witnesses fix this occurrence about the time the raiders were hung. The testimony is given by James P. Stone, page 2212, manuscript, page 956, James Jasper Culver, page 2080, manuscript, page 914, John F. Heath, a rebel soldier, page 786, manuscript, page 317, William Dillard, a rebel soldier, page 803, manuscript, page 328, Calvin Honeycutt, a rebel soldier, page 824, manuscript, page 336, John Pascal, Pask, page 1695, manuscript, page 757, Robert Tate, page 2650, manuscript, page 1133, and James H. Davidson, page 933, manuscript, page 384. Before proceeding to notice the evidence as to the acts of murder committed immediately under the prisoner's orders or by his own hand, allow me to remark that the court, in considering these specific acts, will hardly overlook the confirmatory evidence embraced in the testimony as to the general language and conduct of the accused towards the prisoners. I submit that his language and conduct, as exhibited in the testimony, furnish such evidence of malice as to raise a strong presumption of guilt. Wharton, in his Criminal Law, page 240, speaks of the presumption of guilt from declarations of intentions and threats, from which the presumption of guilt may be drawn with great strength, when there is preliminary ground laid. On this principle, I maintain the numerous well-proven declarations and threats of the accused, evincing his utter indifference whether the prisoners lived or died, nay, his desire that they should die, and his ambition to compete with rebel generals in the field by killing off as many Union soldiers as possible, are justly to be viewed as confirmatory of the evidence in regard to the specific acts of murder laid to his charge, and as similar proof of malice on his part, raising a presumption of guilt against him in reference to specific murderous acts alleged. The court will not, I think, disregard the general evidence of his brutal treatment of prisoners, exhibiting toward them a malignity of temper of which murder would be but the natural outgrowth. The conduct and the expressions of the accused, as proved throughout the whole evidence, show a vindictively malicious feeling towards the prisoners, and this general malice is sufficient to furnish probable cause for the special acts of killing testified to by the witnesses, particularly as in almost every instance of killing the act itself was accompanied by declarations indicating strongly a malicious and willful intent. In discussing the murders alleged to have been committed under the prisoner's direct orders, the first case that claims attention is that in which the victim was a one-legged soldier known among the prisoners as Chickamauga. The court will pardon me for dwelling somewhat at length on this case, as it is one of those two which the prisoner has singled out as the only cases worthy of a serious attempt at defense in connection with the charge of murder. Some of the witnesses who narrate the facts of this occurrence are S. D. Brown, page 457, manuscript, page 183, O. S. Belcher, page 882, manuscript 361, J. R. Acuff, page 1089, manuscript, page 471, Thomas Hall, page 982, manuscript, page 408, J. Adler, page 1215, manuscript, page 532, Gottfried Bruner, page 1333, manuscript, page 589, O. B. Fairbanks, page 1023, manuscript, page 430, E. L. Kellogg, page 1073, manuscript, page 460, A. J. Spring, page 716, manuscript, page 293, C. E. Tibbles, page 2041, manuscript, page 897, J. E. Marshall, page 1716, manuscript, page 767, A. A. Kellogg, page 1319, A. Henshaw, page 2553, manuscript, page 1093, Thomas N. Way, page 1259, manuscript, page 554. The accounts of this occurrence given by these different witnesses with greater or less particularity are entirely consistent as to the main facts, while as to unimportant particulars there is doubtless that slight variation which always characterizes accounts given by different eyewitnesses of the same occurrence, and which, as it excludes the idea of concerted falsification, is the strongest voucher for the good faith and veracity of those who testify. The essential facts which stand out clearly in this mass of testimony, so clearly that the prisoner himself, as I shall presently show, has been driven to a substantial admission of them, are, that a poor, demented cripple, whose imbecile condition was notorious in the stockade and among the guards, sought to be taken from the stockade that he might be protected from the indignation of some of his comrades, who charged that he had reported tunnels to the accused; that after some parleying on the part of Chickamauga with the guard, the prisoner made his appearance, when Chickamauga asked him to be taken out of the stockade, stating the reason for his request, that the prisoner refused to take him out, and ordered the guard, who had shown an unwillingness to treat the poor cripple harshly, to shoot him if he crossed the dead line; that he did subsequently cross the dead line, and the sentry, acting under the direct orders of the prisoner, shot him. Here, I submit, is a clear case of murder. Before going further, it is proper to remark contradictions in the testimony of the witnesses to the Chickamauga affair appear only in the statement of the prisoner, and cannot be discovered by the closest scrutiny of the record. It is not a fact that two of the government witnesses represent the prisoner as having shot Chickamauga with his own hand. Yet the prisoner's version of the evidence would make us believe this, and the supposed conflict of testimony is urged as an illustration of what he terms the murky, foggy, indefinite, and contradictory testimony of the prosecution. I will give the prisoner's ingenious version of the testimony, and then, as contrasting romance with reality, I will present the evidence as given in the record. The prisoner says, page 4770, manuscript page 1944, "One witness, whom for his own sake I will not name, inasmuch as his statements must have been and were recognized by every one who heard him as undeserving the least belief, describes him, Chickamauga, as a kind of weakly man, who, when I entered the stockade one day, wormed around me, saying that he wanted to go out in the air, whereupon Captain Wirz wheeled again, pulled out a revolver, and shot him down." Now, the sober fact is that this witness, in describing and characterizing the prisoner who was shot, mentions no circumstance which can warrant the supposition that he intended to testify as to the Chickamauga affair. The evidence cited by the prisoner is from page 399, manuscript page 150. I read the continuation of the same narrative from page 400. Question: Do you know who the man was that the prisoner shot? Answer: He belonged to the 8th Missouri. They called him Red in the regiment. I knew him at Memphis. Again I quote the prisoner's statement, manuscript page 1846. A still different version of this transaction is given in a more laconic and reckless style by another witness, page 936. I will quote it. Question: Did you ever see Captain Wirz shoot any man? Answer: Yes, sir. Question: When? Answer: About the first day of April, I think, shortly after he took command there. Question: State the circumstances of the shooting. Answer: Captain Wirz was coming in the south gate one day. A sick man, as I took him to be, a lame man, asked Captain Wirz something, and Captain Wirz turned around and shot him. Here again no one has ever pretended that the case is identical with that of Chickamauga, the latter occurring in June and the former in April. When the evidence of the record is treated in this manner, no wonder that it becomes, in the language of the prisoner's statement, murky, foggy, indefinite, and contradictory. It is a little remarkable, too, that after having introduced one of these witnesses as being reckless in his style of narration, and the other as undeserving the least belief, the prisoner, in a later part of his statement, dismisses them both with a concession that they were sincere in their testimony, for he says, page 4776, manuscript page 1948, The two men who swore they saw me shoot the prisoner with my own hand were probably led to make that statement from having seen me draw my revolver in the manner I have described. Let me now notice the prisoner's own version of this Chickamauga affair, a version which he gives us as the solution of the so-called irreconcilable testimony of the prosecution. The facts, as the prisoner would have the court believe them, and believing accept as his exculpation, are given in his own language in this remarkable paragraph. Will the court permit me to make a statement which may serve to explain all these conflicting accounts of the death of poor Chickamauga? On the evening in question, the sergeant or the officer of the guard came to my quarters and stated that there was a man within the dead line jawing with the sentry and refusing to go outside, and that there was a crowd of prisoners around him and a good deal of disturbance. I rode my horse down to the stockade, dismounted outside, and went in. There I found things as they had been described to me. I went up to Chickamauga and asked him in a rough tone of voice what the hell he was doing there. He said he wanted to be killed. I took my revolver in my hand and said in a menacing manner that if that was all he wanted I would accommodate him. I scared him somewhat, and he was taken outside by some of the prisoners. I then, in his presence, and solely as a menace, told the sentry to shoot him if he came in again. I little thought that he would come back, or that his comrades would permit him, after their hearing the order, to go once more across the forbidden line. I left the stockade, remounted my horse, and was on my way back to my quarters when I heard the report of a musket. I hastened back and ran up to the sentry box from which the shot had been fired. There is the simple history of the case, without any reserve or misrepresentation. The court, I am sure, will recognize all the marks and evidence of truth in it. It is consistent with itself, and consistent with the average line of the testimony. I confess that I was greatly surprised when this startling declaration was read for the first time in my hearing, and in the presence of the court 3 days ago. This explanation seems to me to admit so fully the guilt of the prisoner that if it were the mere hypothesis of counsel, adopted as the last resort of a desperate defense, I would decline to hold the prisoner responsible for such damning admissions, which I would be bound to believe his counsel had no authority to make. But here we have the solemn statement of the prisoner, submitted without solicitation and after due deliberation. Charged with the gravest criminality in reference to an occurrence which is attested by a score of witnesses, he volunteers his own explanation, which is taken down from his lips, revised and signed by his own hand, and read before the court in his presence, with no attempt on his part at disavowal, when the impulse which prompted such self-criminating candor had had time to give place to circumspect reserve. Under these circumstances, I believe I am treating the prisoner with entire fairness when I ask the court to hold him responsible for his own words and let him be the witness of his own guilt. I submit that his explanation of this occurrence, so far from exculpating him, exhibits his guilt scarcely less effectively than the evidence of the prosecution. The main fact upon which the government insists is that the prisoner ordered the guard to shoot Chickamauga if he should cross the dead line, and that in the act of crossing it, or immediately afterwards, this wretched imbecile was shot by the sentry in obedience to the prisoner's order. This is not denied in the statement of the prisoner, but is there fully admitted. It is admitted that the prisoner, I quote his own language, told the sentry to shoot him if he came in again. It is admitted that this order was obeyed by the sentry, and that thus Chickamauga was killed. While conceding all this, the prisoner seeks to shield himself under the allegation that the order was given solely as a menace. Yet he does not pretend that he gave the sentry any reason to suppose that the order was not to be obeyed. He does not pretend that the act of the sentinel in shooting was anything else than the natural obedience of a subordinate to his superior's order, which had every appearance of being imperative. When the guilty and murderous act is thus admitted, the criminal cannot seek refuge under his own allegation of an innocent intent, particularly when he acknowledges that that intent was hidden within the recesses of his own mind, and found no shadowing forth at the time in words or acts, but was contradicted by both. The prisoner's allegation of an innocent intent cannot overcome the conclusive presumption of the law that a sane man contemplates the natural and probable consequences of his own acts. When the motive of a man arraigned for crime shall be taken from his own lips, in contradiction of the obvious tendency of his acts, courts of justice will have become obsolete. It is admitted that the order to shoot was given by the prisoner, it is admitted that that order was obeyed, and that thus Chickamauga lost his life. The obedience of the sentry and the death which resulted were the natural and probable consequences of the prisoner's self-confessed act. And as I believe that the order for the shooting of Chickamauga was unjustifiable and cruel, I see not how this court can do otherwise than declare that the prisoner, in this melancholy affair, incurred the guilt of murder. Before leaving this subject, I cannot refrain from making a passing remark on the picture of the prisoner's brutality as painted by his own hand, a picture in singular contrast with another self-portraiture embraced in the same statement. In recounting the Chickamauga affair, the prisoner says, "I went up to Chickamauga and I asked him in a rough tone of voice what the hell he was doing there. He said he wanted to be killed. I took my revolver in my hand and said, in a menacing manner, that if that was what he wanted, I would accommodate him. I scared him somewhat, and he was taken outside by some of the prisoners." How startlingly in contrast with this has the prisoner portrayed himself in another part of his statement. This is his language: I do trust that the enlightened court will bear with me in my humble effort to convince it that while commandant of the prison at Andersonville I was not the monster that I have been depicted as being, that I did not cause or delight in the spectacle of the sufferings, woes, and deaths of the Union prisoners, that I did not contribute to their sufferings, but that, on the contrary, I did what little lay in my power to diminish or alleviate them, and to prove that although I have been represented as little less than a fiend, heaven left some remnant of the angel still in that poor jailer's nature. We are asked to believe that these two portraitures represent one and the same person. If it be so, then unfortunate was it for poor Chickamauga that his untutored mind did not comprehend that that fierce-seeming man who asked him in a rough tone of voice, "What the hell are you doing here?" was at that very moment yearning with compassion for his wretched condition. The poor crazy cripple little dreamed that the stern-spoken man who, revolver in hand, said to him, "If you want to be killed, I will accommodate you," was a poor jailer, in whom the remnant of the angel was struggling to exhibit itself under great difficulties, a lover of mankind in a very embarrassing position, but doing, as he says, what little lay in his power to diminish or alleviate the sufferings of those around him. A John Howard, forsooth, whose compassionate heart prompted him, as he tells you, to take out of the stockade all the drummer boys, in order that the little fellows might, in the enjoyment of purer air and healthful exercise, have a better chance of being restored to their yearning mothers and sisters at home. Alas for poor Chickamauga that he did not whisper in the ear of this rough-mannered philanthropist that he, too, crippled and insane though he was, had a yearning mother or sister at home. Who knows but that the suggestion might have won for Chickamauga a happier fate? But the subject is too serious for satire. I submit that in the many features of this trial, showing with what abandon the prisoner gave rein to his malicious passions, the killing of poor Chickamauga is one of the most despicable and indefensible. The insane cripple had subjected himself to the wrath of his comrades, being led, by the promises of this accused, to turn traitor to them and disclose their means of escape. He had thrown himself upon the protection of his murderer. He had alienated himself from all his companions, while he had done everything to commend him in the sight of the accused. Yet when fleeing from the just indignation of his comrades, which was so great that he even dared to trust his life in the hands of the guards, with death staring him in the face from the sentinel and from his outraged companions, he appeals to this accused, the only man who had the power to aid him in this terrible strait, the one of all others who was under an obligation so to do, and is rudely rebuffed by the man to whom he had rendered a service, brutally repulsed with a violence of manner and language which appears as vividly in the prisoner's own version of the transaction as in that given by the witnesses for the prosecution, and is told to go back to this mob, which is crying for his blood, or that if he did not do this, but remained within the deadline, the sentry would shoot him. It was death to Chickamauga whichever way he went, and this accused must have known it, and must have intended it, else he would have let him out of that horrible place. With what conscience, then, can he ask you to believe him when he tells you he did not intend the death of Chickamauga? This court, I submit, in view of the evidence, must hold the prisoner responsible for the death of that miserable creature. Having presented one of these cases at some length, one which I think will admit of no doubt, I will pass hastily over the evidence bearing upon similar cases, giving a brief analysis and reference to the testimony, leaving the court to arrive at its own conclusions. William Bull, page 2276, manuscript page 977, testifies that on the 3rd of June, at the North Gate, he saw a man shot, that the prisoner came in at the head of a detachment, put 3 guards on the stoop, and ordered them to fire at the crowd to make them fall back, that one of the guards fired, and that the ball struck the man in the stomach, who was about 15 feet distant from the witness. W. W. Crandall, Patrick Bradley, page 1904, manuscript page 849, states that on one occasion, he thinks it was in June, 1864, when the men were crowding around the south gate, the prisoner was there and thought they crowded too much. He ordered the sentry on the outside of the gate to fire, and repeated the order 3 or 4 distinct times. The sentry fired and killed a man who was about 5 feet from the deadline. Jacob D. Brown, page 465, manuscript 186, testifies that on the 27th of July he saw the prisoner in the sentry box near the brook. Some of the prisoners were there getting water, and men would accidentally reach under the deadline. The prisoner told the sentry if any man reached through the deadline to get water to shoot him down. He had barely said the words when a prisoner reached through, and the sentry fired, the ball taking effect in the head, killing him instantly. Witness was close to him. Joseph Adler, page 1211, manuscript page 532, testifies that sometime in July the prisoner was standing in the sentry box when 2 or 3 men were at the brook after water. Some got their hands beyond the deadline, and the prisoner asked the sentry why he did not shoot, as it was no matter whether the man's whole body was over the deadline or only a part of it, that if he did not shoot he would have him punished. The sentry thereupon shot the man in the right breast. He fell into the creek. Bernard Corrigan, page 1346, manuscript page 596, testifies that a few days after the raiders were hung, which was on the 11th of July, a man was shot at the south gate. We were going, he says, for medicine. The man had 2 tin cups in his hands. Wirz told the guard if he did not keep the men back, he would take him off and punish him. He repeated it, saying he had a gun. Wirz turned his back and started off, and the guard fired right among the crowd and shot this man. Joseph R. Acuff, page 1093, manuscript page 473, states that in July they were carrying sick men to the gate. There was a great crowd there. The prisoner told the sentry if the men did not keep back to blow them through. The sentinel had his musket against a man's stomach and drew back and fired, and killed a man from Pennsylvania. Jacob D. Brown, page 467, manuscript page 186, testifies that about the middle of August the prisoner ordered the sentinel to shoot men who were getting water from the brook, the men being much crowded. The sentry fired and a man was shot in the breast, the wound being fatal. Prescott Tracy, page 1417, manuscript page 627, states that in the month of August, 1864, he heard the prisoner order the shooting of a man who had just come in and did not know the rules and regulations; that he went to get a drink and slipped and fell with his head about 6 inches over the dead line; that the prisoner at the bar called to the sentry, "God damn your soul, why don't you shoot that Yankee son of a bitch?" The guard fired, the ball striking the man in the head and coming out at the back of his neck. He died in the creek. See also evidence of Charles E. Smith, page 2538, manuscript page 1085. End of Part 9. Part 4 of Henry Wirz, Commander of Andersonville Confederate Prison, Trial and Execution, by United States Army Staff Judge Advocate. Part 4, Closing Statement of Judge Advocate, Prosecutor. Part 10. We come now to notice that class of murders committed with the prisoner's own hands. I shall here, as elsewhere, avoid all argumentation, and present as briefly as possible the evidence of the witnesses, leaving the court to determine in the light of the principles of law before mentioned what amount of guilt attaches to this prisoner. Your attention is called first to the death of a Union prisoner by beating with a pistol over the head, as given by the witness William Willis Scott. His evidence is as follows, page blank, manuscript page 570. In one case I was coming down after a bucket of water. I belonged way up in what they called the new stockade on the north side. Captain Wirz was coming in. A sick man was sitting on the side of the bank. He asked Captain Wirz if he could get out. Captain Wirz turned around, gave him a kind of a sour look, and said, "Yes, goddammit, I will let you out," and with the revolver he struck the fellow over the head and shoulders several times. The fellow went to his tent then. On the third morning, I think, I made it my business to go down and see him. He was dead. He had died the night before. Q. Did you see him? A. Yes, sir. Q. Did he die from the effects of the beating with the pistol? A. I suppose so. He was pretty badly bruised around the head and face. Q. With what did Captain Wirz beat him? A. I think it was the butt of the revolver which he had in his hand. Q. Which hand did he use? A. I don't remember. Q. Did he knock the man down? A. Yes, sir. He knocked him down the first blow. Q. When was that? A. I think it was about the 25th or 26th of August, 1864. Q. Can you give the man's name? A. No, sir. I did not inquire about that. I just came down to see if he was much the worse for his treatment, and I did not inquire any further. The witness is uncorroborated by any testimony presented, unless the evidence given by Patrick Bradley, page 1899, manuscript page 848, may refer to the same circumstance. I leave it for the court to determine whether the accused shall be found guilty under this testimony. There are given with certainty time, place, and circumstance. The beating is shown to have been wanton, cruel, and malicious, and wholly unprovoked. The only element necessary to make the crime complete is the proof that death was the result of the wounds inflicted. Whether this may or may not be inferred from the circumstances as narrated by the witness, the court must be the sole judge. The prisoner is also charged with the murder of a soldier by stamping upon and kicking him so as to cause his death. The evidence in support of this allegation is given by Martin E. Hogan, page 525, manuscript page 216. I saw Captain Wirz at the time the prisoners were being moved from Andersonville to Millen take a man by the coat collar because he could not walk faster. The man was so worn out with hunger and disease that if he had got the whole world I do not think he could move faster than he was moving. Captain Wirz wrenched him back and stamped upon him with his boot. The man was borne past me, bleeding from his mouth or nose, I cannot say which, and he died a short time afterwards. Q. When you speak of Captain Wirz, you mean the prisoner there? A. I mean the man sitting there, pointing to the prisoner. Q. Have you any doubt of his identity? A. Not at all, sir. I would know him anywhere. Q. About what month was that? A. The prisoners commenced to move from there from the 5th to the 8th of September, 1864, and it was inside of a week from that time. It was sometime in the early part of September. I cannot say within 2 or 3 days what date it was. The character of this witness, his intelligence, and his facilities for observation must impress the court with the fact that his testimony is entitled to more than ordinary weight. It requires no exercise of imagination nor a resort to improbabilities to justify the conclusion of guilt, remembering the character of the accused and his many acts of cruelty, which furnish confirmatory evidence not to be overlooked. Another murder laid to the charge of this prisoner as perpetrated by his own hand is described by George Conway, page 2240, manuscript page 965, who testifies, A. I saw a man shot one day. He came down after water. No one was allowed to put their head or any part of their body under the dead line. This man, probably not being acquainted with the rules, as many of them were not, who came in there after the rules were read, put his hand in under the dead line to get a cup of water, and the cup dropped from his hand. He put his hand in under the dead line to raise it up again, and Captain Wirz shot him, the ball taking effect in his head. He died almost instantly. To the court: Captain Wirz shot him. He was standing in the sentry box. Q. When did this occur? A. Well, it was about the time the raiders were hung. I could not say whether it was before or after. Q. It was about that time? A. Yes, sir. Q. Are you certain you recognized Captain Wirz? A. Yes, sir. Q. You knew him well at that time? A. Yes, sir. Q. Do you know what kind of a gun he had in his hand? A. He had a revolver, I believe. Q. You state that Captain Wirz shot him. Tell the court the circumstances. A. Those were the circumstances. He was getting a cup of water out of the brook when the cup dropped from his hand. Q. Do you know the name of that man? A. I do not. I never saw the man before till I saw him that time. Q. Did he die? A. Yes, sir, he died. The testimony of this witness on other points, as upon this, is clear and distinct, so much so that the counsel on cross-examination seemed to think it unnecessary to interrogate the witness with regard to this very important part of his testimony. He is uncontradicted and must be believed. The next instance of this kind to which your attention is called is given in the testimony of Felix de la Baume, page 1927 to 1933, manuscript page 859. I do not desire to discriminate among witnesses, as it might imply that some are entitled to greater credit than others. Disclaiming any such intention, I still must remind the court of the character of this witness, his manner of testifying, and the air of truth and candor with which he told his story. Upon this point I give his testimony entire and without comment. Answer. On the 8th of July I arrived at Andersonville with 300 or 400 other prisoners, most of them sick and wounded. We were brought up to Captain Wirz's headquarters, were drawn up in a line, 4 ranks deep, and kept there for a considerable length of time without any business being transacted. The guards had orders to let none of us go to the water. One of the prisoners was attacked with epilepsy or fits. He fell down. Some of his friends or neighbors standing near him ran down to the creek after water. Q. By permission of the guard? A. I don't know. I suppose so, because the guard was tied up by the thumbs for permitting them to do so. First, I heard a shot fired without seeing who fired it. After hearing that shot fired, I looked down to the left, and I saw Captain Wirz fire 2 more shots, wounding 2 men. One of them was carried up near his headquarters, and in my opinion he was in a dying condition. Q. What became of the other? A. He was wounded too, but I did not see him again. Q. Did you ever see him afterwards? A. No, sir. Q. How were the men wounded? A. The one who was carried up near the headquarters was wounded somewhere in the breast. Q. What kind of a weapon had Captain Wirz in his hand? A. A revolver. Q. How near were you to him? A. I was perhaps 20 paces distant from him. I am not positive about the distance. Q. How far was the prisoner when he shot? A. Not very far. Q. You are certain you saw Captain Wirz discharge the pistol in his hand? A. Yes, sir. Q. Did the man who was brought up to the headquarters die? A. I did not myself see him die, but he was evidently in a dying condition, judging by his appearance. I never saw him again. We were not allowed to speak to the guard, and I could not make any inquiries. Q. Do you remember any language used by Captain Wirz on that occasion? A. He asked the lieutenant of the guard, "Where is the guard who allowed this man to fall out of the ranks?" The guard was pointed out, and Captain Wirz ordered him to be tied up by the thumbs for 2 hours. After this, Captain Wirz pointed out the man and said, "That is the way I get rid of you damned sons of bitches." Q. Was anything said as to the purpose for which the men left the ranks and went towards the brook? A. I myself saw the man fall down. He had epileptic fits, and I was informed that the men ran after water for him. We had not received any water all night. They kept us all night in the cars. On the way down from Macon to Andersonville we had no water. When we passed the creek we wished to get some water, but we were not allowed to have any. We were kept at the headquarters of Captain Wirz for about 2 hours without receiving a drink. We were then divided into squads and transported into the stockade. Q. When you were ordered into the stockade, was the man who had been shot still lying there, or had he been carried out? A. I was taken out with 4 other men to be put into the 71st detachment, and was shortly afterwards taken away from the headquarters into the stockade. Q. State whether you have any means of judging whether the man died from that gunshot wound. A. All that I can state is that he was, in my opinion, in a dying condition. I judged so from his heaving up and down and from his gasping for breath. I have seen many men on the battlefield in the same condition, and they always died shortly afterwards. Q. Where was the wound? A. The blood was running out from his breast or the middle of his body somewhere. Q. Did you hear anything about it afterwards? A. All I heard of it was from a rebel sergeant, I think his name was Colby, who said the man died. Q. When did he tell you that? A. Some time after I was in the stockade. There is evidence given by Hugh R. Snee, page 2430, manuscript, page 1041, of a double murder committed outside the stockade on the way from the stockade to the depot, and which occurred a little after dark, the victims being Union prisoners who were attempting to make their escape among those going out for exchange. The circumstances, as given by this witness, page 2430, manuscript 1041, are that in September, 1864, when some men were going out for special exchange, there were 2 men belonging to an Iowa regiment who fainted between the prisoners' headquarters and the depot. They fell out of the ranks, and a man ran back and wanted to know why they came out. They said they wanted to get out of prison. A man said, "I will help you out damned soon." The witness heard 6 discharges from a pistol and heard a cry as if some one was hurt. Presently a rebel officer, he thinks a lieutenant, coming along, remarked, "It was a brutal act." Some one asked him who it was, and he said, "The captain." He also said one of them is dead. Witness thought it was Captain Wirz's voice which he heard through the crowd, but could not state positively. There is still another testimony of murders committed by the hand of this prisoner, as given in the testimony of Willis Van Buren, page 1802, manuscript page 802, and James H. Davidson, page 936, manuscript page 386. I desire only to call the attention of the court to the testimony of the witness Snee and the 2 first named as bearing upon this branch of the case, without venturing to express an opinion as to the guilt of the prisoner. There is still one other case of deliberate murder by the hand of this accused. It is that related by George W. Gray, page 2700, manuscript page 1158. The court will remember that during the examination of this witness there occurred one of the most impressive episodes of this trial, which must not be overlooked or forgotten in judging of the truth or falsehood of George W. Gray's narration. He has been severely attacked by the prisoner in his statement to the court, although no contradicting evidence was introduced and no circumstances given which could raise a reasonable doubt for the benefit of this accused. I call the attention of the court to the entire evidence of this witness in relation to the occurrence. He testifies, page 2700, 12567, manuscript page 1158. Question: Do you know anything about the prisoner having shot a prisoner of war there at any time? Answer: He shot a young fellow named William Stewart, a private belonging to the 9th Minnesota Infantry. He and I went out of the stockade with a dead body, and after laying the dead body in the dead house, Captain Wirz rode up to us and asked by what authority we were out there. Stewart said we were there by proper authority. Wirz said no more, but drew a revolver and shot the man. After he was killed, the guard took from his body about $20 or $30, and Wirz took the money from the guard and rode off, telling the guard to take me to prison. Question: Are you sure about that? Answer: If I was not, I would not speak it. Question: By whose orders did you come out with the dead body? Answer: It was my determination, I don't know whether it was Stewart's or not, to get away again. For that reason we went out, we begged for the body. Question: Do you know whether that was the time that Lieutenant Davis had something to do with the prison? Answer: I recollect now that Lieutenant Davis ordered the sergeants of each detachment to detail men to carry out of the stockade the dead bodies of men belonging to that detachment. Question: State what Captain Wirz had in his hand when he shot that soldier. Answer: He had a revolver, whether a navy pistol or not I don't know. It was a large pistol. Question: How near was he to him? Answer: About 8 feet from him, I think. Question: Where did the ball take effect in your comrade? Answer: In the breast. He died right there where he was shot. Question: Were you at the time attempting to make your escape? Answer: No, sir, but it was my intention to do so if I could. I was not attempting it at that time, nor was Stewart. Question: How far were you from the dead house? Answer: About 50 yards, about half the distance from the stockade to the dead house, a little off and to one side of it. Question: You do not know whether Lieutenant Davis had a partial command there? A. I think that in September Captain Wirz was relieved temporarily by Lieutenant Davis on account of ill health for about 2 weeks, probably. Q. Of the fact of Wirz committing this particular offence you are certain? A. I am, sir. Q. When testifying with reference to the man on the white horse, you said something about not being able to identify him. Had you any difficulty afterwards in identifying Captain Wirz? A. The first time I knew such a man in the prison, I heard Lieutenant Davis call his name at the gate. He said, "Captain Wirz, come down this way." I looked at the man and asked the boys if he was not the commander of the Andersonville prison. The judge advocate called upon the prisoner to stand up for identification. The prisoner, who was lying on a lounge, partly raised himself, turning his face to the witness. Q. Do you recognize that man as the person who shot your comrade? A. That is the man. The prisoner attempted to say something in contradiction of the witness, but was not permitted by the court. The judge advocate requested the prisoner to stand upon his feet. The prisoner having complied with the judge advocate's request, the witness looked at him and said, "I think that is the man." Q. The prisoner whom you have been talking about, you were in the habit of recognizing in the prison as Captain Wirz? A. Yes. Q. Do you recollect whether the man who shot your comrade had a foreign accent? A. I took him to be a German or a foreigner by his talk. For this reason, when I was put in the stockade, he said to me, "Gott damn you, I fix you." For that reason I took him to be a foreigner or a Dutchman. This impression of the scene, one of the most remarkable occurring during the trial, as the witness Gray confronted the murderer of his companion, was such as this court and all who were present will never forget. The witness was cautioned to be careful, and told that it was a very serious matter about which he was to speak. But there was no trepidation, no hesitation, no doubt discoverable in his manner, and I think all who heard him must have felt that he spoke only the truth when he said, "That is the man." You are told on the part of the defence that this witness is not to be believed, and among the reasons it is urged that on cross-examination he said that he thought the prisoner rode a roan horse, while the general testimony is to the effect that the prisoner usually rode a gray mare, and that he afterwards saw him on a sorrel horse. I would remind the court that Mr. Gray is not the only person who describes the prisoner as riding a roan horse, and I need hardly remind counsel, so prolific of negative evidence, that men who usually ride gray horses have been known to ride sorrel horses. Another reason urged why Gray's story is not to be believed is that it is improbable. A complete answer to this is found in the conduct of this accused towards the prisoners of war in his custody. No act of brutality was improbable with him, no provocation was needed, but like the infamous Vargas, killing with him was but a pleasant recreation and seemed the business of the hour. Again, you are told that Gray is not to be believed because he mentioned a circumstance of cruelty, the bayoneting of soldiers, which was brought out by no other witness. Is this so surprising a fact that this court must reject the whole evidence of a witness otherwise supported? This whole record has been made up, not by calling a few witnesses who narrate all that occurred at Andersonville, but by calling very many, each of whom brings with him the knowledge of facts which, from the very necessities of their surroundings, were not always in the possession of others. Gray's statement of the cruel bayoneting of our soldiers at Andersonville is entirely consistent with the treatment they met from the beginning to the end of that horrible prison. I insist, gentlemen, that the evidence of George W. Gray is entitled to your highest consideration, and although it alone fixes upon the prisoner at the bar guilt which can only be expiated by the highest punishment known to the law, you cannot resist the proof. I have thus, without regard to the evidence under charges first, presented the evidence under charge second, as spread upon the record, showing that this accused, while acting as commandant of the prison at Andersonville, deliberately, wantonly, and maliciously destroyed the lives of 18 prisoners of war in his custody. I confess myself too much overcome with the melancholy details of this trial and the frightful disclosures to dwell longer on so sad a theme. If this accused still answer that, admitting the facts charged, he did these things in the exercise of authority lawfully conferred upon him, and that what he did was necessary to the discipline and safety of the prisoners, I answer him in the language of Lord Mansfield, given in an important case. In trying the legality of acts done by military officers in the exercise of their duty, particularly beyond the seas, where cases may occur without the possibility of application for proper advice, great latitude ought to be allowed, and they ought not to suffer for a slip of form, if their intention appears by the evidence to have been upright. It is the same as when complaints are brought against the inferior civil magistrates, such as justices of the peace, for acts done by them in the exercise of their civil duty. There the principal inquiry to be made by a court of justice is, how the heart stood, and if there appear to be nothing wrong there, great latitude will be allowed for misapprehension or mistake. But on the other hand, if the heart is wrong, if cruelty, malice, and oppression appear to have occasioned or aggravated the imprisonment, or other injury complained of, they shall not cover themselves with the thin veil of legal forms, or escape, under the cover of a justification the most technically regular, from that punishment which is your province and your duty to inflict on so scandalous an abuse of public trust. Wall versus McNamara. May it please the court, I have hastily analyzed and presented the evidence under charge second. If we have not traveled through the history of those long, weary months of suffering, torture, starvation, and death, and become familiar with each day's roll of those who passed away, the mind could not contemplate this last, though briefer, roster of the dead without feelings of utmost horror. Mortal man has never been called to answer before a legal tribunal to a catalogue of crime like this. One shudders at the fact, and almost doubts the age we live in. I would not harrow up your minds by dwelling further upon this woeful record. The obligation you have taken constitutes you the sole judge of both law and fact. I pray you administer the one and decide the other, meting out to those involved in this crime of the universe all justice, without fear, favor, or partiality, and without regard to position, high or low, of those proved guilty. N. P. Chipman, Colonel and Additional Aide-de-Camp, Judge Advocate. End of Part 10. Part 5 of Henry Wirz, Commander of Andersonville Confederate Prison, Trial and Execution by United States Army Staff Judge Advocate. Part 5, Finding and Sentencing of Court. The court, being cleared for deliberation, and having maturely considered the evidence adduced, find the accused Henry Wirz as follows. Of the specification to charge 1, guilty, after amending said specification to read as follows. In this, that he, the said Henry Wirz, did combine, confederate, and conspire with them, the said Jefferson Davis, James A. Seddon, Howell Cobb, John H. Winder, Richard B. Winder, Isaiah H. White, W. S. Winder, W. Shelby Reed, R. R. Stevenson, S. P. Moore, Kerr, late hospital steward at Andersonville, James Duncan, Wesley W. Turner, Benjamin Harris, and others whose names are unknown, citizens of the United States aforesaid, and who were then engaged in armed rebellion against the United States, maliciously, traitorously, and in violation of the laws of war, to impair and injure the health and to destroy the lives, by subjecting to torture and great suffering, by combining in unhealthy and unwholesome quarters, by exposing to the inclemency of winter and to the dews and burning suns of summer, by compelling the use of impure water, and by furnishing insufficient and unwholesome food, of large numbers of Federal prisoners, to wit, the number of about 45,000 soldiers in the military service of the United States of America, held as prisoners of war at Andersonville, in the State of Georgia, within the lines of the so-called Confederate States, on or before the 27th day of March, A.D. 1864, and in divers times between that day and the 10th day of April, A.D. 1865, to the end that the armies of the United States might be weakened and impaired, and the insurgents engaged in armed rebellion against the United States might be aided and comforted, and he, the said Henry Wirz, an officer in the military service of the so-called Confederate States, being then and there commandant of a military prison at Andersonville in the State of Georgia, located by authority of the so-called Confederate States, for the confinement of prisoners of war, and as such commandant, fully clothed with authority, and in duty bound to treat, care, and provide for such prisoners held as aforesaid, as were or might be placed in his custody, according to the law of war, did, in furtherance of such combination, confederation, and conspiracy, maliciously, wickedly, and traitorously confine a large number of prisoners of war, soldiers in the military service of the United States, to the number of about 45,000 men, in unhealthy and unwholesome quarters, in a close and small area of ground, wholly inadequate to their wants and destructive to their health, which he well knew and intended, and while there so confined, during the time aforesaid, did, in furtherance of his evil design and in aid of the said conspiracy, willfully and maliciously neglect to furnish tents, barracks, or other shelter sufficient for their protection from the inclemency of winter and the dews and burning sun of summer, and with such evil intent did take and cause to be taken from their clothing, blankets, camp equipment, and other property of which they were possessed at the time of being placed in his custody, and with like malice and evil intent did refuse to furnish or cause to be furnished food, either of a quality or quantity sufficient to preserve health and sustain life, and did refuse and neglect to furnish wood sufficient for cooking in summer and to keep the said prisoners warm in winter, and did compel the said prisoners to subsist upon unwholesome food, and that in limited quantities, entirely inadequate to sustain health, which he well knew, and did compel the said prisoners to use unwholesome water, reeking with the filth and garbage of the prison and prison guard, and the offal and drainage of the cook-house of said prison, whereby the prisoners became greatly reduced in their bodily strength, and emaciated and injured in their bodily health, their minds impaired and their intellects broken, and many of them, to wit, about the number of 10,000, whose names are unknown, sickened and died by reason thereof, which he, the said Henry Wirz, then and there well knew and intended, and so knowing and evilly intending did refuse and neglect to provide proper lodgings, food, or nourishment for the sick, and necessary medicine and medical attendance for the restoration of their health, and did knowingly, willfully, and maliciously, in furtherance of his evil designs, permit them to languish and die from want of care and proper treatment. And the said Henry Wirz, still pursuing his evil purposes, did permit to remain in the said prison, among the emaciated sick and languishing living, the bodies of the dead, until they became corrupt and loathsome, and filled the air with fetid and noxious exhalations, and thereby greatly increased the unwholesomeness of the prison, insomuch that great numbers of said prisoners, whose names are unknown, sickened and died by reason thereof. And the said Henry Wirz, still pursuing his wicked and cruel purpose, wholly disregarding the usages of civilized warfare, did at the time and place aforesaid maliciously and wilfully subject the prisoners aforesaid to cruel, unusual, and infamous punishment, upon slight, trivial, and fictitious pretenses, by fastening large balls of iron to their feet, and binding numbers of the prisoners aforesaid closely together with large chains around their necks and feet, so that they walked with the greatest difficulty, and being so confined were subjected to the burning rays of the sun, often without food or drink for hours and even days, from which said cruel treatment numbers whose names are unknown sickened, fainted, and died. And he, the said Wirz, did further cruelly treat and injure said prisoners by maliciously tying them up by the thumbs and wilfully confining them within an instrument of torture called the stocks, thus depriving them of the use of their limbs and forcing them to lie, sit, and stand for many hours without the power of changing position, and being without food or drink, in consequence of which many, whose names are unknown, sickened and died. And he, the said Wirz, still wickedly pursuing his evil purpose, did establish and cause to be designated within the prison enclosure containing said prisoners a dead line, being a line around the inner face of the stockade or wall, enclosing said prison, and about 25 feet distant from and within said stockade, and having so established said dead line, which was in some places an imaginary line, and in other places marked by insecure and shifting strips of boards, nailed upon the top of small and insecure stakes or posts, he, the said Wirz, instructed the prison guard stationed around the top of said stockade to fire upon and kill any of the prisoners aforesaid who might fall upon, pass over or under, or cross the said dead line, pursuant to which said orders and instructions, maliciously and needlessly given by said Wirz, the said prison guard did fire upon and kill a number of said prisoners. And the said Wirz, still pursuing his evil purpose, did keep and use ferocious and bloodthirsty dogs, dangerous to human life, to hunt down prisoners of war aforesaid, who made their escape from his custody, and did then and there wilfully and maliciously suffer, incite, and encourage the said dogs to seize, tear, mangle, and maim the bodies and limbs of said fugitive prisoners of war, which the said dogs, incited as aforesaid, then and there did, whereby a number of said prisoners of war, who during the time aforesaid made their escape and were recaptured, died. And the said Wirz, still pursuing his wicked purpose, and still aiding in carrying out said conspiracy, did cause to be used for the pretended purposes of vaccination impure and poisonous vaccine matter, which said impure and poisonous matter was then and there, by the direction and order of said Wirz, maliciously, cruelly, and wickedly deposited in the arms of many of said prisoners, by reason of which large numbers of them lost the use of their arms, and many of them were so injured that they soon thereafter died. All of which he, the said Henry Wirz, well knew and maliciously intended, and in aid of the then existing rebellion against the United States, with the view to assist in weakening and impairing the armies of the United States, and in furtherance of the said conspiracy, and with the full knowledge, consent, and connivance of his co-conspirators aforesaid, he, the said Wirz, then and there did. Of charge 1, guilty, after amending said charge to read as follows: maliciously, wilfully, and traitorously, and in aid of the then existing armed rebellion against the United States of America, on or before the 27th day of March, A.D. 1864, and on divers other days between that day and the 10th day of April, 1865, combining, confederating, and conspiring together with Jefferson Davis, James A. Seddon, Howell Cobb, John H. Winder, Richard B. Winder, Isaiah H. White, W. S. Winder, W. Shelby Reed, R. R. Stevenson, S. P. Moore, and Kerr, late hospital steward at Andersonville, James Duncan, Wesley W. Turner, Benjamin Harris, and other unknown, to injure the health and destroy the lives of soldiers in the military service of the United States, then held and being prisoners of war within the lines of the so-called Confederate States, and in the military prisons thereof, to the end that the armies of the United States might be weakened and impaired, in violation of the laws and customs of war. Of specification first to the charge 2, guilty, adding the words or about immediately before the phrase the 9th day of July. Of specification second to charge 2, guilty. Of specification third to charge 2, guilty, after striking out June and inserting instead September. Of specification 4 to charge 2, not guilty. Of specification 5 to charge 2, guilty, after striking out the phrase on the 30th day and inserting instead the phrase on or about the 25th day. Of specification 6 to charge 2, guilty, after striking out the word first and inserting 15th, and also striking out the phrase on the 6th day and inserting instead the phrase on or about the 16th day. Of specification 7 to charge 2, guilty, after striking out the word 20th and inserting instead the word first, and also after inserting or about immediately before the phrase the 25th day. Of specification 8 to charge 2, guilty. Of specification 9 to charge 2, guilty. Of specification 10 to charge 2, not guilty. Of specification 11 to charge 2, guilty, after striking out the word first and inserting instead the word sixth, after striking out also the phrase incited and urge, and the phrase encouragement and instigation, and by adding the words or about after the word on, where at last occurs in the specification, and also after striking out the phrase animals called bloodhounds and inserting the word dogs, and also striking out the word bloodhounds where it afterwards occurs and inserting the word dogs, and also striking out the words given by him. Of specification 12 to charge 2, guilty. Of specification 13 to charge 2, not guilty. Of the second charge, guilty. And the court do therefore sentence him, the said Henry Wirz, to be hanged by the neck till he be dead, at such time and place as the President of the United States may direct, 2/3 of the members of the court concurring herein. Lew Wallace, Major General and President Committee. M.P. Chipman, Colonel and Additional A.D.C. Judge Advocate. And the court also find the prisoner Henry Wirz guilty of having caused the death in manner as alleged in specification 11 to charge 2 by means of dogs of 3 prisoners of war in his custody and soldiers of the United States, one occurring on or about the 15th day of May, 1864, another occurring on or about the 11th day of July, 1864, another occurring on or about the 1st day of September, 1864, but which finding as here expressed has not and did not enter into the sentence of the court as before given. Lew Wallace, Major General and President of Committee. N.P. Chipman, Colonel and Additional A.D.C. Judge Advocate. End of Part 5. Part 6 of Henry Wirz, Commander of Andersonville Confederate Prison, Trial and Execution, by United States Army Staff Judge Advocate. Part 6. Report of Staff Judge Advocate to the President. Report of the Judge Advocate General, War Department, Bureau of Military Justice, October 31, 1865. To the President. Henry Wirz was tried by a military commission convened at Washington, D.C., on the 23d day of August, 1865, by order of the President of the United States, on the following charges and specifications. Here follow the charges and specifications. Upon being arraigned, the prisoner's counsel submitted the following pleas. First, that he ought not to be held or tried for any cause by the government of the United States, because according to the terms of the surrender of the rebel General Johnson, under whose command he was serving at the time, it was agreed that all officers and men should be permitted to return to their homes, not to be disturbed by the United States authorities so long as they observed their obligations and the laws in force where they resided. Second, that he should not be held to trial or in custody because at the time of his arrest he was in the enjoyment of his liberty, and was promised by Captain Noyes, of Major General Wilson's staff, that he should not be held as a prisoner, but that after giving such verbal information to General Wilson as he was able, he should have a safe conduct to his home, which promise was violated. Third, that the commission had no jurisdiction to try him for the offences charged; also that he had been on the 21st of August arraigned and put on trial before the same tribunal on the same charges, and could not be tried or put to answer a second time therefore; also that the charges and specifications were too vague and indefinite, and did not make out an offence punishable by the laws of war. All these pleas were discussed at length on both sides, and were, after deliberation, properly overruled by the commission. A plea of not guilty to both charges and specifications thereto was then made by the prisoner. The investigation of the matters alleged against the prisoner then commenced and continued until the 21st day of October, during which time 148 witnesses for the prosecution and defense were examined, and a large amount of documentary evidence found in the official papers captured at Andersonville and among the rebel archives at Richmond was introduced. One of the counsel for the defense then asked for an adjournment of 2 weeks at least to enable him to prepare an argument. The commission first decided to adjourn 10 days, and upon his further petition 12 days for this purpose. He, however, declared that it was insufficient time, and thereupon announced that he would submit the case without remark. After an adjournment of 4 days, an elaborate statement of the prisoner was submitted, which was prepared by him with the aid of an able assistant, the chief reporter of the trial, who shows himself familiar with all the material facts; which goes over the whole case in explanation of certain acts averred, and in denial of the proof or truth of all the others. The closing address of the judge advocate immediately followed, and thereafter the court, it appears, having maturely considered the evidence adduced, found the accused Henry Wirz as follows. Here follow the findings and sentence of the court. It is not necessary for the purpose of this review to go into an elaborate discussion of the questions involved in the findings on the first charge. From the document of the proceedings, containing more than 500 pages, presenting a mass of evidence bearing upon these questions, no brief summary can be made which would do justice to the subject. The argument of the judge advocate sets forth an able and exhaustive examination of the material legal points raised and proof established by the trial, and forms a part of the record. It may be relied on as giving a full and just exposition of the matters which entered into the deliberations of the court, and as particularly applicable to this branch of the case. Reference is respectfully invited to page 4838 to 5148. The opinion is expressed that the conspiracy, as described in the findings above recited, was clearly made out, and that the conclusions arrived at by the court could not, in the light of the evidence this record contains, have been avoided. Language fails in an attempt to denounce even in faint terrors the diabolical combination for the destruction and death by cruel and fiendishly ingenious processes of helpless prisoners of war who might fall into their hands, which this record shows was plotted and deliberately entered upon, and as far as time permitted, accomplished by the rebel authorities and their brutal underlings at Andersonville prison. Criminal history presents no parallel to this monstrous conspiracy, and from the whole catalogue of infamous devices within reach of human hands, a system for the murder of men more revolting in its details could not have been planned. Upon the heads of those named by the court in its findings, the guilt of this immeasurable crime is fixed, a guilt so fearfully black and horrible that the civilized world must be appalled by the spectacle. There remains yet to be noticed the matter involved in the second charge. The homicides alleged to have been committed under this charge, and which the court found were committed, are of four classes. First, those classes of death which resulted from the biting of dogs, specification 2. Second, cases of death which resulted from confinement in the stocks and chain gang, specifications 5, 6, and 7. Third, cases of prisoners killed by guards pursuant to direct orders of Wirz given at the time, specifications 8, 9, 12. Fourth, cases of prisoners killed by Wirz's own hand, specifications 1, 2, 3. That all the deaths embraced in these four cases resulted from the causes and in the manner set forth in the specifications is conceived to be very clearly established by the evidence adduced by the prosecution, and it is not deemed necessary, in the absence of any contradictory testimony directly bearing on these instances, to recite the evidence applicable to each, except, it may be, briefly, that relating to the fourth class, specifications 1, 2, 3, and some acts of a similar character. The testimony supporting the first specification is that of Felix de L'Arbaum, a Union soldier, who states that on or about the 8th of July, 1864, he was one of a detachment of prisoners taken to Wirz's headquarters to be enrolled before being sent into the prison; that one of his comrades was attacked with epilepsy, and some of his companions, by permission of the guard, ran to the creek for water; that he, the witness, heard a shot fired, and on turning saw Wirz fire 2 more, wounding 2 prisoners, one of whom the witness never saw nor heard of afterwards, and the other of whom he saw carried up to Wirz's headquarters in a dying condition, the wound being in the breast. There is also the testimony of George Conway, who states that on or about the 11th of July, 1864, he saw Wirz shoot a Union prisoner within the stockade as he was stooping to pick up his cup, which had fallen under the dead line, and that the man died almost instantly. Which of these two cases, either being, it is conceived, sufficient to sustain the allegation the court relied on, does not, of course, appear. In support of the second specification, Martin E. Hogan testifies that sometime in September, when the prisoners were being removed from Andersonville to Millen, he saw Wirz take a prisoner who was worn out with hunger and disease by the coat collar, and because he could not walk faster, wrench him back and stamp upon him with his boots; that the man was borne past him, witness, bleeding from his mouth and nose, and died in a short time. The third specification is supported by the testimony of George W. Gray, who states that about the middle of September, 1864, he and a comrade named William Stewart, a private belonging to a Minnesota regiment, went out of the stockade, in charge of a guard, to carry a dead body, and that after laying it in the dead house, they were on their way back to the stockade, when Wirz rode up to them and asked by what authority they were out there; that Stewart replied they were out there by proper authority; whereupon Wirz drew his revolver and shot Stewart; the ball taking effect in his breast and killing him instantly, and that the guard then took from his body some $20 or $30, which Wirz received and rode away. Further evidence in regard to Wirz killing certain prisoners was presented, but the dates given by the witnesses show the murders to have been other than those alleged in the specifications. They will be referred to as illustrating the character of the prisoner and establishing a frequency and repetition of like crimes. James H. Davidson testified that in April, as he remembered, Wirz came into the stockade one day, and a lame man went up to him and asked him a question, whereupon Wirz turned round and shot him, and he died. Thomas C. Alcock states that one day, the witness seems to have no knowledge or recollection of dates, Wirz came into the stockade, and a man asked of him permission to go out and get some fresh air. That Wirz asked him what he meant, and that after a few more words had passed between them, Wirz wheeled round, pulled out a revolver, and shot him down, the ball taking effect in his breast, and death occurring about 3 hours afterwards. It also appears by this witness that when he remonstrated, Wirz told him he had better look out or he would be put in the same place, and that soon after Wirz came in with a guard and put him in irons. Hugh R. Snee testifies that sometime in September 1864, a party of Union prisoners were to be exchanged under an arrangement between General Sherman and the rebel Hood, that they were taken from the stockade after dark, as the heat in the day was so great that the men would have fainted, that none but able-bodied men were selected, it being stated when they were called out that any one who could not walk 18 miles a day would be shot. That notwithstanding this, the men were so anxious to escape imprisonment that some, too weak to perform the day's travel, came out. The witness states that 3, who belonged to some Western regiments, were able to go but a short distance before they fainted and fell out of the ranks and were pushed one side by the guard. That thereupon a man ran back, and speaking in a voice he thought at the time to be that of Captain Wirz, wanted to know why they were there, that they replied they wished to get out of prison, whereupon this man said, "I'll help you get out, God damn you." Witness then heard 6 pistol shots, followed by a cry as if some one was hurt, and immediately after a rebel lieutenant came past remarking that it was a brutal act. That one of them was dead, and when asked who did it, replied, "The captain." The most prominent features of the defense under this second charge will now be considered. An attempt was made to prove that during the whole of August and parts of July and September the prisoner was sick and confined in his bed, and could not have committed the crimes charged to him in those months. In his statement to the court, however, he made no reference to his absence, doubtless for the reason that the testimony was of too general and loose a character to set up as contradictory to the explicit statements of numerous witnesses as to the dates when the crimes recorded in the finding were committed, corroborated as those statements were by official papers bearing his signature, showing that at different times during those months he was in the performance of his ordinary functions as commandant of the prison. It was claimed that deaths resulting from the use of dogs in the capture of escaped prisoners were not crimes fastened upon Wirz, he not being present at the pursuit and therefore not responsible. But it appears to have been the fact that this use of dogs was under Wirz's special direction, that the pursuit of prisoners was in many instances initiated under his immediate orders, and in some cases captures were made under his personal supervision. It was also clearly proved that a part of each pack were ferocious dogs, dangerous to life, so as to make it probable that the men on whose track they were sent would be killed. A man overtaken by these beasts and desiring to surrender could not, by coming to a stand, save his life. The instinct of the dogs was for human blood, and to surrender to them was death. A most shocking illustration will be given. 2 soldiers had escaped, but were overtaken. The party who captured them returned with but one, who was so mangled that he died, and the chief of the party, known as Turner, exulted in accounting for the other, stating that they allowed the dogs to tear him in pieces and left him in the woods. As applying to the question of criminal responsibility involved in this class of homicides, the judge advocate referred the court to the well-settled principle of law that it is not essential that the hand of the party should be the immediate occasion of the death, but that if it be shown that means were used likely to occasion death, and which did so occasion it, the party using such means is to be held responsible for the consequences. There is but one of this class of homicides which enters into the findings of guilty under this charge. A discussion of the legal points involved is conceived to be needless, inasmuch as the charge is sustained by a conviction on 9 other distinct allegations of murder. As to the deaths resulting from the use of stocks and chain gangs, the defense urged that the men were placed therein for the purposes of discipline, that they were commonly used for such purposes, and that their use at this place was attributed to those higher in authority than Wirz, to whose orders he was subject. Upon this point it is to be observed that prisoners were put in these instruments of torture as punishment for having escaped, or having made attempts to escape from their captors, which attempts, whether successful or not, it was their right and duty as prisoners of war to make. Any punishment inflicted upon them, therefore, by their captors was a violation of the laws of war, and deaths resulting from such unlawful punishment are murders. This would be the judgment of the law apart from some of the peculiar circumstances which surround these crimes, and which so decidedly indicate their true character, prominent among which is the often declared animus of the prisoner, showing conclusively that in these and kindred barbarities he was deliberately seeking to sacrifice the lives of his victims. It was shown that these stocks and chain gangs were under Wirz's immediate and direct control, that he exercised full authority in committing prisoners to both. While it may be and probably is the fact that his action in this matter was sanctioned by the rebel Winder when he was on duty at that place, it does not relieve the prisoner of responsibility for the result. Relating to the 3 homicides embraced in the 3rd class, the prisoner makes no special defense, except as to the killing of the man known as Chickamauga. He urges in his final statement that his order to the guard to shoot this man was only intended as a menace. It is clear, however, from the testimony that his order in this case, as in the others, was peremptory, and, according to his own version, it was not a command that could be construed by any subordinate as merely a menace. Moreover, it was distinctly proved to have been accompanied by a threat that he would shoot the guard if the guard did not shoot this crippled soldier. He states further, and it is so found by the record, that this poor man desired to be killed, it would seem, because he was suspected by his comrades of having given information to the prison keepers of some attempts of prisoners to escape from the stockade. This fact, however, in no degree palliates his murderous guilt. Of the homicides embraced in the 4th class, those committed directly by his own hands, the prisoner's statement notices but one, that of Stewart, sworn to by the witness Gray. It is asserted that the testimony of this witness is a pure fabrication. There is nothing found in the examination of the record which casts a doubt on his veracity, and the court seemed to have discovered nothing in his manner on the stand to raise the question of his credibility. As to all those cases not heretofore specially mentioned, the defence insists that the allegations were too vague and indefinite, and that the testimony is insufficient to sustain them, and also that it is altogether improbable that such murders could have been committed without coming to the knowledge of various witnesses, who stated that they had never heard of such crimes at Andersonville. No evidence being submitted which contradicts the concurrent and explicit statements of the witnesses who gave positive testimony of their perpetration, these murders are fastened to Wirz's hands. Many points were raised by both sides relating to the admission of evidence as the trial progressed. These were fully debated at the time. No discussion of them here is deemed necessary, it not being found that competent proof material to the prisoner's defence on the specific offences of which the court pronounced him guilty was excluded. Much latitude seems to have been given him. He was allowed to show special acts of kindness to prisoners, and to introduce declarations made by himself in explanation of his acts. Letters and official reports and oral testimony of his personal efforts offered as indicating his interest in and a care for the comfort of the prisoners were also admitted. It is shown that every witness asked for by the defence was subpoenaed except certain rebel functionaries who, for reasons stated at the time, did not appear on the stand. But the judge advocate proposed that if the counsel for the defence would set forth, according to the common rule by affidavit, what he expected and had reason to believe any witness who did not so appear would testify, it would be admitted of record that such witness would so testify. This proposition was not accepted. 106 witnesses were subpoenaed for the defence, of whom 68 reported, but 39 of these, many of them soldiers of our army and sufferers at Andersonville, were discharged by the prisoner's counsel without being put upon the stand. A review of the proceedings leads to the opinion that no prejudice to the legal rights of the prisoner can be successfully claimed to have resulted from any decision which excluded testimony he desired to introduce. The trial is believed to have been conducted in accordance with the regulations governing military courts, and the record presents no error which can be held to invalidate the proceedings. The annals of our race present nowhere and at no time a darker field of crime than that of Andersonville, and it is fortunate for the interests alike of public justice and of historic truth that from this field the veil has been so faithfully and so completely lifted. All the horrors of this pandemonium of the rebellion are laid bare to us in the broad, steady light of the testimony of some 150 witnesses, who spoke what they had seen and heard and suffered, and whose evidence, given under oath and subjected to cross-examination and to every other test which human experience has devised for the ascertainment of truth, must be accepted as affording an immovable foundation for the sentence pronounced. The proof under the second charge shows that some of our soldiers, for mere attempts to escape from their oppressors, were given to ferocious dogs to be torn in pieces; that others were confined in stocks and chains till life yielded to the torture, and that others were wantonly shot down at Wirz's bidding or by his own hand. Here, in the presence of these pitiless murders of unarmed and helpless men, so distinctly alleged and proved, justice might well claim the prisoner's life. There remain, however, to be contemplated crimes yet more revolting, for which he and his co-conspirators must be held responsible. The Andersonville prison records, made exhibits in this case, contain a roster of over 13,000 dead, buried, naked, maimed, and putrid in one vast sepulchre. Of these, a surgeon of the rebel army who was on duty at this prison testifies that at least 3/4 died of the treatment inflicted on them while in confinement, and a surgeon of our own army, who was a prisoner there, states that 4/5 died from this cause. Under this proof, which has not been assailed, nearly 10,000, if not more, of these deaths must be charged directly to the account of Wirz and his associates. This widespread sacrifice of life was not made suddenly or under the influence of wild, ungovernable passion, but was accomplished slowly and deliberately by packing upwards of 30,000 men, like cattle, in a fetid pen, a mere cesspool where to die for need of air to breathe, for want of ground on which to lie, from lack of shelter from sun and rain, and from the slow, agonizing processes of starvation, when air and space and shelter and food were all within the ready gift of their tormentors. This work of death seems to have been a saturnalia of enjoyment for the prisoner, who amid these savage orgies evidenced such exultation and mingled with them such nameless blasphemy and ribald jests, as at times to exhibit him rather as a demon than a man. It was his continual boast that by these barbarities he was destroying more Union soldiers than rebel generals were butchering on the battlefield. He claimed to be doing the work of the rebellion, and faithfully in all his murderous cruelty and baseness did he represent its spirit. It is by looking upon the cemeteries which have been filled from Libby, Belle Isle, Salisbury, Florence, and Andersonville, and other rebel prisons, and recalling the prolonged sufferings of the patriots who are sleeping there, that we can best understand the inner and real life of the rebellion, and the hellish criminality and brutality of the traitors who maintained it. For such crimes human power is absolutely impotent to enforce any adequate atonement. It may be added in conclusion that the court before which the prisoner was tried was composed of officers high in rank and eminent for their faithful services and probity of character, and that several of them were distinguished for their legal attainments. The investigation of the case was conducted throughout with patience and impartiality, and the conclusion reached is one from which the overwhelming volume of testimony left no escape. It is recommended that the sentence be executed. J. Holt, Judge Advocate General. End of Part 6. Part 7 of Henry Wirz, Commander of Andersonville Confederate Prison, Trial and Execution by United States Army Staff Judge Advocate. Part 7, Order of the President and Letter Re-Execution and Burial. Order of the President, General Court-Martial Orders No. 607, War Department, Adjutant General Office, Washington, November 6, 1865. 1. Before a military commission which convened at Washington, D.C., August 23, 1865, pursuant to paragraph 3, Special Orders No. 453, dated August 23, 1865, and paragraph 13, Special Orders No. 524, dated October 2, 1865, War Department, Adjutant General Office, Washington, and of which Major General Lewis Wallace, United States Volunteers, is President, was arraigned and tried Henry Wirz. Here follow the charges, specifications, findings, and sentence. 2. The proceedings, findings, and sentence in the foregoing case having been submitted to the President of the United States, the following are his orders. Executive Mansion, November 3, 1865. The proceedings, findings, and sentence of the court in the within case are approved, and it is ordered that the sentence be carried into execution by the officer commanding the Department of Washington on Friday, the 10th day of November, 1865, between the hours of 6 o'clock a.m. and 12 o'clock noon. Andrew Johnson, President. 3. Major General C.C. Augur, commanding the Department of Washington, is commanded to cause the foregoing sentence in the case of Henry Wirz to be duly executed and in accordance with the President's order. 4. The military commission, of which Major General Lewis Wallace, United States Volunteers, is President, is hereby dissolved. By command of the President of the United States, E. D. Townsend, Assistant Adjutant General. Official, E. D. Townsend, Assistant Adjutant General. Letter of the Commanding General, Department of Washington, reporting the execution and burial of Henry Wirz. Headquarters, Department of Washington, Washington, D.C., November 11, 1865. Sir, I have the honor to report that the sentence and orders of the President in the case of Henry Wirz, as promulgated in General Court-Martial Orders No. 607, dated War Department, Adjutant General's Office, Washington, November 6, 1865, have been duly executed between the hours of 10 and 11 a.m. yesterday, November 10, and his body has been interred by the side of Atzerodt in the Arsenal grounds. I am, General, very respectfully, your obedient servant, C.C. Augur, Major General, Volunteers, Commanding Department, the Adjutant General of the Army. End of Part 7. End of Henry Wirz, Commander of Andersonville Confederate Prison, Trial and Execution, by United States Army Staff Judge Advocate.